Welcome back to the deep dive. We are continuing our exploration of the Manual of Patent Examining Procedure, the MPEP.
That's right.
This is all part of our larger series where we're systematically, trying to work our way through this essential guide from the U.S. Patent and Trademark Office.
Bit by bit.
Exactly. Today we're zeroing in on Chapter 1200, which lays out all the rules and procedures for appeal within the USPTO.
And specifically within Chapter 1200, we're really digging into MPEP Section 1202. It's titled Composition of Board.
Oh, okay, composition of the board.
Yeah. So our goal here really is to unpack what this section tells us about the structure, the legal foundation, and also the operational power of a really critical body. The Patent Trial and Appeal Board. You probably know it as the PTB.
Right, the PTB. Hear that acronym a lot.
We do. And we're drawing directly from the MPP text itself and some related regulations, just to understand who is actually making these decisions and, how they do it.
Okay, let's unpack this then. The MPEP says the PTAB has a specific legal basis, doesn't it? It didn't just, appear out of thin air.
No, exactly.
Yeah.
According to the source material we looked at, the foundation for the PTA is set right there in the law, under 35 U.S.C. Section 6.
Section 6, okay.
So that gives it a really clear statutory mandate. It's meant to be there.
Got it. So the law creates the board, and then MPEP 1202 tells us who actually sits on it. So who are these individuals? Who's making these important calls?
Well, this section spells out the composition pretty clearly. You've got the top leadership of the USPTO involved, so the rector, the deputy director, and the commissioners for patents and trademarks. And then sort of the core decision makers, the administrative patent judges, the APJs.
APJs. Right.
And these judges, they're appointed by the Secretary of Commerce, but in consultation with the director.
And it's not just anyone who can be an APJ, is it? I think the source highlighted a specific requirement.
Oh, absolutely. The MPP really emphasizes this. These APJs must possess competent legal knowledge and scientific ability. That combination is key.
That sounds like a really deliberate mix of expertise. You need the legal brain for procedure and patent law, but also the scientific or technical chops to really get the technology.
Precisely. Because the decisions they're making aren't just purely legal. They're about applying that law to often really intricate technical details.
Makes sense.
Which, leads us right into what this board actually does. This is where it gets really interesting. What are the PTAB's core responsibilities according to this section?
Yeah, what's on their plate?
So the source lists their primary duties, and it covers a pretty wide range of critical actions in the patent process. They review examiner rejections and ex parte appeals under Section 134A.
Okay, ex parte appeals. That's probably the most common one, right? Where an applicant challenges the examiner saying no.
That's probably the bulk of it, yes.
Yeah.
When an applicant challenges that initial refusal. But they also handle reexamination appeals under Section 134B.
Reexamination, so challenging patents that already exist.
Exactly. Based on prior art, usually. So, yes, if an applicant disagrees with an examiner's no, or if someone else challenges an already granted patent with new info, the PT heaves the body that reviews that decision. The source gives that exact example. Applicant challenged rejection, appeal goes to a PT panel.
Okay.
But their duties go further. They conduct derivation proceedings under Section 135.
Derivation. That's about figuring out who the real first inventor was.
That's the one. And significantly, they manage the post-grant trial proceedings that came in with the American Invents Act, the AIA. So inter partes reviews or IPRs and post-grant reviews, PGRs. Those are under Chapters 31 and 32.
Right. IPRs and PBRs, those feel more like actual trials, don't they?
They're definitely more trial-like, often complex proceedings, challenging issued patents.
Yeah.
So yeah, it's a broad scope. Application appeals, inventorship questions, full-on patent challenges.
Wow, that is a wide range. How do they actually manage all of that? Structurally, I mean.
Yeah, that brings us to a really crucial operational detail from the source, the three-member panel rule.
Oh, yeah.
For all those major proceedings we just listed, ex parte appeals, derivation proceedings, IPRs, PGRs, the decisions are made by a panel of 3 members of the board.
3 members, not just one judge.
Not for the final decision in those cases, no.
Well.
It ensures multiple perspectives weigh in on these important matters. And the source is clear. Only the PTB itself has the authority to grant rehearings in these situations.
Okay, so final calls on the big stuff need that 3-judge panel. Now, the MPP also talks about the history. You mentioned the AIA. The name wasn't always PTB, was it?
Correct. The source brings up the significant changes from the Leahy-Smith America Invents Act, the AIA. And one of those shifts, procedurally and legally, was renaming the board.
What was it before?
It used to be the Board of Patent Appeals and Interferences, the BPAI.
BPAI. Okay, I remember that.
The AIA changed the name to the Patent Trial and Appeal Board, PTB.
Was that just a simple name swap, or did the new name reflect something more, like new duties?
It was definitely more than just cosmetic, and the name reflects that, adding trial to the name.
Right, from appeals and interferences to trial and appeal.
Exactly. That signals those new trial-like proceedings, the IPRs and PGRs, that the AIA created and gave to the board. So same core institution, but with expanded duties. And the MPP clarifies, if you see BPAI, or even older names in legal documents, you now legally interpret that as meaning the PTP.
That makes sense. The name evolved with the job description. Good clarification. Are there any other nuances in how the board is defined? You mentioned the source points to 37 CFR section 41.2.
It does, yeah, and that regulation adds a helpful layer of detail. It draws a distinction based on the type of action.
How so?
Well, when you're talking about final actions, the ultimate decision in an appeal or a contested case like an IPR of the board specifically means a panel of the board, those three members we discussed, or sometimes the chief administrative patent judge acting under delegated authority.
Okay, the panel or the chief judge for the final word.
Right. But for non-final actions, think more procedural steps, orders that aren't the final decision on the merits of the support is defined more broadly. It could be any single board member or even an authorized employee handling administrative tasks.
Ah, okay. So a high-stakes final decision needs the panel structure or the chief,
Yep.
but less critical non-final stuff can be handled by just one person or staff. That clarifies things. And who exactly counts as a board member in that definition? Is it just the APJs?
According to the regulations cited in the MPPP, the term board member
Right.
is actually quite broad. It includes the top brass, the Undersecretary of Commerce for Intellectual Property, the director, the commissioners,
Wow. Yep.
and all the administrative patent judges. So it's a fairly inclusive term within that context.
So putting this all together, what does this deep dive into MPP Section 1202 really mean for you, the listener? Whether you're navigating the patent system, maybe facing an appeal, or just trying to understand how this key part of the USPTO actually functions.
I think it really shows that the PTAB isn't just, another administrative office. It's the designated internal authority for reviewing these really critical decisions. Understanding its composition, that blend of legal and scientific expertise, and its wide-ranging duties, from fairly standard appeals all the way to complex patent trials like IPRs, that's absolutely essential if you're involved in the system.
Right.
Knowing that final decisions usually come from multi-member panels, and that only the PTK handles rehearings. It gives you real insight into the structure of how decisions get reviewed after the examiner or even after a patent is granted. It's the body that often has the final internal say on so many critical points in a patent's life. Understanding how it's built and how it operates is just key to navigating those stages effectively.
It really does sound like a central hub for resolving these kinds of disputes within the whole patent system. Very important to understand. And before we wrap up, a special thank you to Mike Shepard. He's the creative director who organized this entire audio series, diving into the MPEP section by section.
Absolutely. And, as required, we need to include the disclaimer provided with the source material. So, here it is. Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEI, a qualified instructor, or a registered patent practitioner.
Thank you for joining us for this deep dive into MPP Section 1202. We really hope this gave you a clearer picture of the Patents Trial and Appeal Board, the PTB.
And maybe one final thought to leave you with, building on what we discussed. We talked about how APJs need both competent legal knowledge and scientific ability. So consider this. How might the specific technological field of a patent, say biotech versus software versus mechanical influence, which APJs get assigned to a panel, and could the specific background of those judges potentially shift the balance of which arguments, maybe the purely legal ones versus the deeply technical ones, end up being the most persuasive in that particular case? Something to think about.